Good morning and welcome to this procedural hearing in preparation for the hearing of evidence, which is planned for the 20th of September of this year. Now, what we propose is, first of all, I will invite counsel to the inquiry to say something about how he intends to conduct the hearing in September and the content he intends to bring to it. After counsel has completed what he has to say, there'll be an opportunity for questions if questions arise. I will then say something about the procedures that we intend to follow, and again there will be the opportunity, probably in the course of what I have to say, for the legal representatives to ask questions. So I will begin by inviting counsel to the inquiry to explain how he intends to proceed in September.
Thank you, Lord Brodie. As you know, first night of hearings in the Scottish Hospital inquiry is set to commence on the 20th of September. At the meeting on the 18th of March, I indicated that the purpose of these hearings would be to hear and to record the evidence of patients and families. I said that their stories would be our starting point. I want to say something today in a little more detail about that, about what the evidence will cover, and about how I intend to conduct the hearings. I will start with what it is the hearings will cover. As I see it, the Scottish Hospital inquiry is not a broad inquiry into the construction of hospitals in the east and the west of Scotland. Certainly, in due course, we will be exploring many detailed technical issues from procurement through to commissioning and perhaps even to maintenance of the hospitals. But these issues are of importance to us only insofar as they link to the possibility of adverse impacts upon patients. That is why we begin the substantive hearings where we do. We want to find out from patients and from families what their perceptions of those impacts might be. The terms of reference identify a number of respects in which these perceptions are of importance. Most obviously, Term 8 requires the inquiry to look into the physical and emotional and other effects of the aforementioned construction and other issues upon patients and families. In this regard, a particular emphasis is placed within Term 8 upon infections and possible links to the hospital environment or environmental organisms. Term 8 also requires the inquiry to consider the nature and the effectiveness of communication with patients and families. It is my intention to lead and to place evidence before the inquiry in September in relation to the foregoing matters. I have set out the likely parameters of the evidence in a list of topics that accompanies Direction 3, and Direction 3 is the one that concerns the opening statements at the hearing in September. But it might be helpful if I said a little bit more about the nature and parameters of the evidence covered by the list of topics. It seems likely that most of those who give evidence will be people who have experience of the Glasgow hospitals, the QE, UH and the RCH. The evidence will come from patients and from families, and the core elements of that evidence will be as follows. Witnesses will be asked to identify and to describe any particular problems that they encountered during treatment or involvement with the hospitals. Those problems may include health issues experienced by patients, most obviously infections that impacted upon care and upon health. Another example is the use of prophylactic antibiotics and the impact that that may have had upon treatment and indeed upon health. But we'll also look at other sorts of problems. One obvious example is emotional impacts upon families, particularly the parents of affected children. We may also look at the perception that they have on amenities within the hospital, particularly for those who were decanted to different parts of the hospitals. Finally, and as indicated, witnesses will be asked about their perception of communication and the effectiveness of that. Now, presently it seems likely that there will be a smaller group of witnesses in relation to Edinburgh. Again, the list of topics sets out the broad framework, but the key element is the same in each case. The effect that the delayed move to the hospital had upon them, whether they are patients or whether they are a family member, and the perception of communication around that. I now wish to say something about how I intend to deal with the September hearings. I begin with the hearings themselves. I cannot emphasise enough that the focus of the hearings in September is the witnesses' perceptions of what happened to them. In a very real sense, I intend to do no more than gather their evidence that we can then use in our further investigations. And so, consistent with that, I do not see challenging the evidence in September in any way as being part of my remit at this point. It is possible and perhaps quite likely that not everyone who provides a statement will provide oral evidence. The inquiry team will make provision for vulnerable and anxious witnesses, but I recognise that some people may still prefer not to give oral evidence. In that situation, we may simply read in the witness's statement so that it formally becomes part of the evidence before the hearing. We may proceed similarly where we have a number of witnesses from one family group. Lord Brodie will explain in a moment the procedural framework within which the hearings will be conducted. The only thing I would say about that is again to repeat something that I've already said before. It is my intention to adopt as open and collaborative an approach as I possibly can, and in keeping with that, I would encourage parties' representatives to keep in touch and not to hesitate to raise any issue that they may have. I hope what I've just said has been of some assistance to you this morning, but I'm more than happy to field any questions just now that you may have. Thank you very much.
Thank you. Are there any questions that arise at this stage? I should say that there'll be an opportunity at the end for you to come back on anything that occurs to you, having reflected on everything that's said. Right, I'm not seeing any questions. Can I move, therefore, to say a little bit about the procedural framework which we intend to adopt? The hearings will be held in the office accommodation that the inquiry has secured just off St Andrews Square in Edinburgh. These office premises are in course of being fitted out. There will be office accommodation. There will also be a hearing room with associated witness room and some provision for legal representatives. The layout as planned is, broadly speaking, a courtroom layout with a familiar structure. The weeks that we have set aside for the hearing are 5 weeks beginning on the 20th of September with a break. So there will be 3 weeks between the 20th of September and the 8th of October, and there will be 2 weeks between the 25th of October and the 5th of November. My strong preference is to hear the evidence of witnesses in person. Now that will involve witnesses coming to the office in Edinburgh and attending for the period of their evidence. Now we have a witness support team that will welcome and advise witnesses. We hope to be able to fit the evidence of witnesses into timed slots with a view to avoid witnesses waiting unnecessarily. So the plan will be that a witness will have an idea not only of when their evidence will begin, but when it's planned to be completed. Now, I appreciate that where a witness is a client of one of the legal representatives will wish to liaise perhaps with witnesses before they give evidence, and we will try and facilitate that by providing space for that to happen. Everything, of course, I have said and will say is subject to the qualification that we are in a situation where the primary concern is health and safety in the context of a COVID pandemic. So we will, everything we do will be informed by current government restrictions, and we will endeavour to follow the best practice when it comes to social distancing and other measures. Now that clearly will have an impact on what space we have available to us. And a pretty obvious consequence of that is that while the plan would be to have witnesses, myself as the chairman, counsel and necessary support staff present during the hearings, there may really be not much a possibility of other people being present. In order to address that, we not only will there be a simultaneous YouTube live stream, but we're making provision for taking evidence remotely, should that be required. And similarly, there will be the possibility of legal representatives joining the inquiry remotely. Although, as I say, my preference is for people to be there. Now, we have considered the possibility of making provision of a remote or a venue in Glasgow where those who wish to follow the inquiry but do not have the access to the technology to do so without assistance. But again, in the context of the pandemic, there are quite significant resource implications in setting up a remote venue for viewing. So can I ask legal representatives to consult with their clients to identify if there is a need for such a facility, to find that out from clients and get back to the inquiry as soon as possible. As part of the access to the inquiry, a transcript will be posted on the website within 2 or 3 days of each day's hearing. Now, as I say, is there any questions that arise thus far? Right. I'm not seeing any questions. We don't anticipate that every core participant would wish to be participative, be involved at every diet of hearings. Therefore, we have made provision and you will have seen there's a protocol directed at that for an application for leave to appear. We would propose to allow a maximum of 2 legal representatives to those who have indicated the wish to appear and who've been granted leave. As I say, the leave to appear protocol is now on the website. You will have seen that we have adopted what might be thought as a hierarchy of procedural measures. We have directions, and Counsel to the Inquiry has already made reference to one of the directions. As it were, at a lower level of generality, we have the protocols, more detailed, and it may be that we issue notes of guidance in addition to that. Possibly the most important protocol in relation to the hearings is the hearings protocol. Now, what we have done is to issue a hearings protocol in draft, and I would hope it's been circulated. As far as the 20th of September is concerned, it will remain a draft document, and quite frankly, we will see how well it works. But it's been issued for the purpose of consultation, and if any of the core participants have any observations on the draft hearings protocol, we'd be grateful if we hear from them before the 23rd of July. I will repeat this, but as Counsel to the Inquiry has said, our approach, insofar as this is, we can achieve this, is to seek and welcome cooperation from core participants. We see that this is a group activity. And by way of example, if you feel that there are improvements that can be made in the draft hearings protocol, or there's problems with the draft hearings protocol, we will be grateful to hear from you on that topic. Now, you should also have available to you the indicative timetable of key events by which particular actions should be taken, actions required from core participants, actions which will be carried out by the inquiry. Now, I'll come back to that, but what I intend to do, subject to any comment that you may have, is to formally adopt the indicative timetable as an indication of when things have to be done. Among the things that will have to be done is distribution to the legal representatives of witness statements and supportive documentation. We aspire to do that within or before 7 or 10 days before the beginning of the hearings, and this may be issued in batches. That will be subject to an obligation of confidentiality. We haven't formally decided how to, or rather we haven't decided yet how formally to express that obligation of confidentiality. Among the possibilities would be a restriction order. Can I again just pause to ask any questions or comments, but in particular any views on the indicative timetable, because if it is acceptable, I will simply adopt it this morning. Mr. Gray.
Yes, thank you, my Lord. There is just one issue in relation to the proposed timetable which I would wish to raise. And that is as to whether consideration may be given to the provision of witness statements before the date on which written opening statements are to be lodged. In order that, looking at the position of those whom I represent, for example, any issues or themes in witness statements which have not been anticipated may be addressed if thought appropriate in the written opening statement. And that would therefore provide the Lord and core participants in advance of the hearing with a clear understanding of the board's position in relation to evidence likely to be led. And it occurred to me that if the timetable were adjusted in that respect, that might be helpful to the inquiry.
I'm going to give counsel to the inquiry an opportunity to make his contribution. In an ideal world, I see the force of what you say, Mr. Gray. In other words, you would wish notice of evidence that is anticipated before framing your written opening statement. I rather fear that that is not practical. We were discussing earlier this week progress on taking witness statements. Now, there are a number of practical issues in relation to that. For example, sometimes witnesses have been obliged to cancel appointments for perfectly good reasons, but that is simply one example of a challenge facing the witness team. Now, quite frankly, I think there may be, I certainly can't, I'm not in a position to commit to being able to provide witness statements prior to, I think the 4th of September is the date that we've suggested for lodging the written statements. Now, it occurs to me that having heard your point, we may be able to circulate some witness statements earlier, may or may not. But, as I say, having heard your point, it might be possible to take a particular view on the extent to which you might reasonably expand in making an oral opening statement on your written statement, it being accepted that it may be that you've not been able to anticipate a line of evidence. Before coming back to you, Mr. Gray, I'm going to ask counsel if he has any observations.
I think I'd probably just echo what Lord Brodie has just said. Neither he nor I is involved in the process of taking statements, so it's not really for us to make any commitments this morning on behalf of others. But there's certainly, I suspect, room for flexibility in relation to this, at least in relation, from my point of view, at least in relation to discussing with any of you what the likely scope of the hearing is going to be in more detail. And I think the other side of the coin for me on that discussion is, what is it that you see the purpose of the opening statement as being? And that might be something that we could usefully think about too, because certainly for my part, I'm not sure I see the purpose in a detailed assessment of each individual witness and what you think of their evidence prior to their giving their evidence, but that'll be a matter that you'll take your own view on. I think that broadly from my point of view, I think this might be something that we go away and reflect on further and that we discuss with you as we go along. and that we keep under review.
Mr. Gray, do you want to take your question any further?
No, thank you, my Lord. My Lord's indicated it is extremely helpful, and I look forward to having discussions with counsel to the inquiry in due course, just to explore the practicalities further and to ascertain what further may be capable of being done. But I'm very grateful, my Lord.
Yeah. Does anyone else have a question or a point? I don't see that. So what I intend to do is adopt reasonably and cooperatively. We've touched on the topic of opening statements. Now, as the legal representatives are well aware, the Rule 10 of the rules which govern the inquiry subject to directions by the chairman provide for the making of an opening statement at the commencement of the first of any hearing inquiry, any inquiry hearings. I prepared a direction in draft indicating that I did not consider that opening statements would be useful and set that out for consultation. In the light of consultation and the feedback that we received, I was persuaded by what was said that at least as far as the hearings in September of this year are concerned, it would be helpful to have opening statements. Now, the mechanism, as you will see, which I've adopted, is to make a general direction to the effect that there will be no opening statements at hearings, but, as it were, taken out of that generality by a separate direction specific to the hearings beginning on the 20th of September, that it will be open to core participants who have leave to appear, if they so wish, to make an opening statement. Now, they will be required, and Mr. Gray has touched on this already, they will be required to prepare and provide to the inquiry by the 4th of September their opening statement in written form. At the hearing itself, a core participant who has provided such a written statement will have the opportunity to speak in support of that opening statement for a period not in excess of 60 minutes. There's no obligation to make an opening statement if a core participant doesn't wish to, and there will be it won't be held against them in any way if they don't. Core participants will be invited at the end of the hearing, possibly not immediately at the end of the hearing, but at the end of the hearing to make closing statements, again in writing, the extent to which they will be required to speak to that written statement is a matter which we can address at the time. That, I think, covers the points that I intended to mention this morning. At risk of repetition, can I again say we expect cooperation and we feel that we're receiving cooperation and we are open to discussion, suggestion, and if there are ways which it appears to the legal representatives that we could be doing things better, we are open to listen to anything that is said. And as Counsel has said, he's open to informal approaches and discussion just as and when that appears to be convenient. Now, are there any other questions or comments which the legal representatives would wish to direct either to me or to Counsel? Well, thank you very much for your attendance, and I look forward to see at least some of you in reality in September, although it will all be dependent on the course of the pandemic and the government's response to that. But thank you very much for being with us this morning. Thank you.